Pose with the bands. Pose with the pose with the pose with the bands. Pose with the pose with the pose with the bands. Pose with the bands. Pose with the bands.
So for the first question, which is question 2A, the question states that one of the partners in a travel agency, without informing other partners, arranges a separate tour package deal with a customer using the firm's resources but keeps the profit for herself. When other partners discover this, they argue that partner has breached duty as partner. So based on the above situation, describe the right of the other partner. So for the introduction, to explain more about partnership and the duties, once a partnership between two or more persons is established, there is a law which governs the relationship between partners to each other. The law provides certain rights and imposes certain duties upon each partner. So breach any of the duties, for example, may give the right to the other partners to take legal action. The law that we can relate to this question. So under section 26 clause A of the Partnership Act, explains how capital profits and losses are to be shared among partners by default, unless there is a specific agreement stating otherwise. All partners are entitled to an equal share of the profits, and they must also contribute equally to cover any losses. This rule applies even if the partners contribute different amounts of capital. In theory, every partner should provide an equal amount of capital. However, in reality, this is not always the case. One partner may contribute money, while another may contribute skills, knowledge, or expertise instead of cash. This arrangement depends on what is agreed upon between the partners. If partners want profit and losses to be divided based on how much capital each person contributes, then this must be clearly stated in the partnership agreement. Without such an agreement, the law assumes that all partners share profits and losses equally regardless of their level of contribution.
There are some cases that related for this section, which is section 26, but we decided to choose the most related cases for this question, which is Bentley v. Craven 1853. So the case is a partner in a sugar refinery, which is Craven, secretly supplied sugar to the firm from his own stock, selling it at a profit without telling the other partner. So the court held he had to account for the profits and hand them all to the firm. So the conclusion for these cases, the profit which came from a transaction concerning the partnership business, whether it's buying or selling the product of the firm, even though he argued the firm benefit by getting sugar, he still breached his duty. The conclusion is, based on the question, the partner has breached her duty under Section 26A of the Partnership Act 1961 by secretly arranging a tour package deal using the firm's resources and keeping the profit for herself without consent. Based on case such as Bentley v. Craven, in the previous slide, any profit that made from the transactions concerning the firm's business belong to the partnership and not belong to the individual partner. Therefore, she must account for and surrender the profit to the firm, and the other partners have the right to claim it and take appropriate action.
Okay, next we move to the next question, which is question 2B. The question is, a partner receives money from a client on behalf of the firm but later misapplies it for his personal use. Based on the above, briefly explain, are the other partners liable? For introduction, partnership law governs the relationship between partners and third parties. One key principle is that partners are agents of the firm, and their action in the ordinary course of business bind the firm. This includes receiving money from clients. However, if one partner misapply the money for personal use, the issue arises whether the other partners are liable or not. For the law, liability for misapplication of money or property of the third person. Section 13 provide where one partner acting within scope of his apparent authority receives money or property of a third person and misapply it. Also, where a firm in the course of its business receives the money or property of a third person, and the money or property so received is misapplied by one or more of the partnership in its custody of the firm. The ability for misapplication of the money or property of the person arises in two cases, which is money or property is received by a partner or firm under Section 11 of the Partnership Act 1890. The firm is responsible for misapplication of money or property by a partner.
So for my part, I will talk about British Home Assurance Corporation Ltd versus Patterson cases. So what happened in these cases? In these cases, a partner of firm received money from a client in his ordinary course of business. But instead of handling the money to the firm, he misapply the money for his own personal purpose. After the client found out about this, the client sued the firm to recover the money. So, in what is the main issue in these cases? The main issue in these cases is whether the other partners liable for the wrongful act misapplication of the co-partners. So, the court decision are the firm was liable for the misapplication money. This is because the money was received by a partner in the ordinary course of partnership business. Like Zarif talked earlier, under Section 11 of the Partnership Act 1918, the firm is responsible for the misapplication money or property by a partner, even if the misapplication was done without the knowledge or consent of the other partners, and even if the misapplication only made by one partner without other partner involved. So, this case confirmed that rule the partners share liability for wrongful acts committed by partner while acting within the scope of the partnership business. So, that's all for the cases. Let's move to the next part. So based on previous cases I explained earlier, we can apply this thing into question scenario. The partner received money from a client on behalf of the firm, which fall within the ordinary course of business. Under Section 11A, although he later misapplied the money for his personal purpose, the firm is still liable to the client because the receipt was within his authority. However, under Section 13, the guilty partner must identify the firm and the other partner for the loss suffered. This means while the client may sue the firm and all the partner, internally the dishonest partner bears ultimate responsibility to reimburse the others. So for the conclusion, we can conclude that under Section 11, partners are liable to the client if he wrongful act happened in the course of partnership business. This is because partner is an agent for the firm. But under Section 13, guilty partner must compensate the firm for the damages caused. So, from the client's perspective, the firm as a whole are responsible, but within the firm, accountability falls under the business partner. This balance is what makes partnership law fair. It protects outsiders who deal with the firm while also maintaining fairness between the partners themselves.